State of Wisconsin, Circuit Court, Manitowoc County, Branch 1. State of Wisconsin Plaintiff versus Stephen A. Avery, Defendant. Motions hearing, case number 05 CF381. Date, January 19, 2007. Before the Honorable Patrick L. Willis, Circuit Court Judge. Appearances, Ken Kratz, Tom Fallon, Norm Gunn, all special prosecutors on behalf of the state of Wisconsin. Dean Strang, Jerome Buting, attorneys at law on behalf of the defendant. Stephen Avery appears in person. The court. At this time, the court calls State of Wisconsin versus Stephen Avery, case number 05 CF381. We are here this morning for a motions hearing. Will the parties state their appearances for the record, please? Attorney Kratz, on behalf of the state of Wisconsin, Your Honor, Ken Kratz, Calumet County District Attorney. Norm Gunn, Assistant District Attorney for Milwaukee County. Tom Fallon, from the Department of Justice, all appear as special prosecutors. Attorney Strang, Stephen Avery appears in person. Jerome Buting of Buting and Williams to my left and on his behalf. And Dean Strang of Hurley, Burrish, and Stanton as well. The court, all right, I will indicate for the record that I met briefly with counsel in chambers before we began to take an inventory of motions that are outstanding and set up in order, which will be addressed this morning. The first motion is the state's motion for relief from the pretrial scheduling order. Mr. Kratz, Attorney Kratz, Mr. Gunn will handle that motion. The court, okay, Mr. Gunn. Attorney Gunn, Your Honor, I believe that the motion that we filed speaks for itself. We're just asking the court, today was the deadline for us to turn over rebuttal witnesses, and in light of recent events, we're asking to be relieved from that because we may need to do some additional testing. We don't know yet if we will, but we're asking the court to relieve us from that responsibility to reveal any of our rebuttal witnesses, expert witnesses especially, today. And I've cited a state v. Konkol, Konkol, in support for this request. And I also ask for, and also our own discovery provisions under 971.23, Section 1D, which basically excludes rebuttal witnesses from what a district attorney must disclose to the defendant. The court, all right, will it be Mr. Strang or Mr. Buting? Attorney Buting, I've got it, Judge. We don't have a real concern about the request, assuming that it's limited to this issue of the blood vial and whether there's any other testing that can still be done on it. I don't know that at this point that there is any, and they haven't decided if there is anything yet at all. But assuming that it is limited to that and that something is ongoing between now and the next few weeks, we don't have any objection to extending this time for them to file any kind of notice. And frankly, I'm sure that Mr. Gunn would share with us whatever results they are going to come up with anyway. I don't think that he's intending to do some ambush on this issue. The court, Mr. Gunn. Attorney Gunn, Your Honor, I don't want this to be limited to just the blood vial situation. It may involve other witnesses' testimony as far as the thwarting or attacking the defense that may be presented in this case. So I don't want to just limit to that one area. We have some additional investigation to look at in a lot of some recent documents that have been filed by the defense. So we may not want that limited at all to just the blood vial, but all aspects of the defense, the location of the vial, where it was, who had custody of it, everything. It's all related. It surrounds all that issue. But it's not just to that. It may be other testimonial evidence. The court, your motion refers to the blood vial and other related evidence. So I take it that you're not looking for a blanket relief from the requirement of the pretrial order, but you are pointing out that to the extent that the other evidence relates to the blood vial, That's the nature of your request? Attorney Gunn. That's correct, Your Honor. The court. Mr. Buting. Attorney Buting. Well, I'm not sure how other related evidence would involve expert witnesses. I thought that's what he was referring to here. The court's order, paragraph 4B4. I don't have it right in front of me, but the court, it provides that the state shall provide to the defense the identity of any rebuttal witness, expert witness the state intends to call, along with the copies or reports of any such expert on or before January 19. Goes on to provide the state may request additional time if necessary based on the nature of any proposed but previously unanticipated testimony of any named defense expert. Attorney Buting. So again, I'm not sure what other kind of expert testimony might be involved in this, but as long as it's not a blanket exemption from the courts, I think the court does have discretion to impose these kinds of deadlines. The court did impose the deadlines and imposed the deadlines against the defense as well, which we have complied with. So I think that maybe there needs to be some more clarification on this later if there's something that we're not anticipating here. But otherwise, the court, let me ask this. I understand based on previous arguments and information presented to the court related to the type of testing that might be involved, that it may be difficult for the state to put any timetable on when information might be presented to the defense. But can there be a description in terms of so much time before such evidence would be offered that the information would be presented to the defense? Attorney Gunn, I don't know if I can commit to that, Your Honor, because it's just, I don't know exactly, depending on future rulings, where we're going to be going. I guess at this juncture, I would inform the court that as far as the expert testimony, I suspect that testimony will be pertaining to the vial, but there may be other lay witnesses that we're presenting to thwart the overall defense of, we're talking the location, the security, and everything involved in the defense. And I simply would ask the court to perhaps recognize State v. Kunkel and what the court has held, that the statutory language, which basically states that the state does not have to turn over its rebuttal witnesses to the defense. The court, Mr. Buting. Attorney Buting. Well, on the other hand, the court did impose the December 15 deadline for the discovery of all types of discovery. Now, obviously, some discovery may be forthcoming based on additional investigation that they had been doing, but I would expect the state would be required or should be required to turn over such discovery immediately as soon as they get it, rather than, holding it back as some ambush that they're going to present in the rebuttal, whether it's lay or otherwise. I think that the discovery, the ongoing duty to supplement the discovery, should require prompt compliance, as we have been doing. We have turned over 7 reports just in the last few days, in fact. The court, all right, what I'm going to do is this. The motion, as I understand it, requests relief from the pretrial scheduling order in order to allow the state to conduct scientific testing on the blood vial and other related evidence. I believe that this type of extension was contemplated at the time of the pretrial order was issued, so I'm going to grant the request as it's framed. I'm gathering from the argument of the parties that other issues could arise that may be contested, but they haven't been presented specifically to the court at this time, and I'm not going to speculate about those. However, given the recent time frame within which the evidence described in the motion was first presented to the state, I'm going to grant their motion. The next item is the state's demand for compliance with discovery requests. And I believe that relates to the January 5 defense disclosure of potential expert witnesses. Who will be arguing this motion for the state? Attorney Gunn. I will, Your Honor. The court. Mr. Gunn, you may proceed. Attorney Gunn. Your Honor, I'm basically going to rely upon the brief we filed in this matter. I would simply highlight what is stated in our statute of 971.23 2M AM, which simply states that if that any relevant written or reported statements of a witness named on the list under paragraph A, including any reports of, or statements of experts made in connection with the case, or if the expert does not prepare a report or statement, a written summary of the expert's findings or the subject matter of his or her testimony, including the results of any physical or mental examination, scientific test, experiment, or comparison that the defendant intends to offer in evidence at trial. It clearly states that summary of the expert's findings and reading what the defendant has submitted certainly does not come anywhere close to telling us what are the findings of their expert. They have not supplied any written expert reports which have been prepared by their experts, and they have not provided us with a summary that is telling us what the findings are. They have simply told us that their experts may or may not testify to something. They may agree, they may challenge, they may disagree with what our experts have come up with. This is telling us absolutely nothing. I don't believe they are complying with the statute, and I believe that the case that we cited, the Schroeder case, certainly stands for that proposition, that they tell us something. I mean, this isn't really difficult. It's quite simple. If they're going to call these experts to testify, tell us what they're going to say, what is the issue, and what their findings, what their conclusions, not this general broad, they may discuss some topic that is so broad in nature that there's no way for us to determine exactly what their testimony is going to be. So what I would ask the court to require them to make this a more definite and more certain, and provide us with a written summary of what their findings are. I did speak with Mr. Buting in our motion. We also talked about the October 6th discovery demand that we filed that pertains to the DNA evidence specifically. Mr. Buting is going to look at that motion that we filed, that discovery motion that we filed, and my understanding is that he's going to get with his expert and will comply as best he can with that. So we needn't discuss that. I believe that Mr. Buting will do that, and I take him at his word and will provide us with the necessary information that we have asked for. But overall, we still believe that we have not been, that the statute has not been complied with. The court, Mr. Buting, Attorney Buting. Judge, I assume the court got the letter that I faxed yesterday. The court, it did. Attorney Buting. Okay, I think we have more than adequately complied with the statute. And in particular, the way the statute reads is, really, one of three things can be done. If a report is prepared, then the report is turned over. However, if there's no report prepared, then the statute says a written summary of the expert's findings, and that's the important thing, or the subject matter of his or her testimony. And as I understand the state's complaint is that the disclosure doesn't specifically list each and every finding, if that's the way that they want to determine it, but the statute doesn't require that. The statute requires a summary of the subject matter of his or her testimony in lieu of that. Now, we actually do include certain findings. There are some opinions specifically expressed in there of what we anticipate Dr. Fairgrave may testify about in particular, as well as Dr. White. It's perhaps a little less, it's a little more vague maybe on the DNA expert, Dr. Freeman, but in part, that's because we explained in the last paragraph that we're not offering any specific test results or manipulation of data to the genotype or various software types of things. So I think clearly we have complied with the statute as to the description of the subject matter. And really, the Anderson case that I point out to the court, first, before I get to that, the language of this witness may testify about that, or, rather than will testify, is really simply a reflection of the fact that none of these experts may testify at all. The defense doesn't have to present any evidence. And so what we're saying is that by using the language that is obviously this witness may or may not testify. If the witness testifies, this will be the subject matter of their testimony. So to clear up any confusion about that, there's no uncertainty as to what the subject matter will be if they testify. And in Anderson, Anderson, the state was permitted to introduce a witness at trial without any kind of expert disclosures under the discovery statute, but simply saying in a motion in Lamont that an expert will testify about the dynamics of child sexual abuse, and or actually I think the specific phrase was, I don't recall it exactly, but the witness was not even named, much less any written summary of what they were going to say. All that was disclosed that there would be an expert unnamed in an area that affects child abuse and disclosure and all that. And the court said that, in their view, satisfied this discovery statute requirement of a written summary of an expert's findings or subject matter of his testimony. So if that was adequate in Anderson, this is way more than adequate under the statute. As Schroeder says, State versus Schroeder, Schroeder, the state cites, the purpose of the discovery statutes is to enable the other side to prepare for trial, not to do a preparation for them. We have done that. We have presented the witnesses, the experts that we may use. If they testify, these are the subject matter. I think that we were very specific as to what it is, what the subject matter they would testify about, and there are some actual findings included in there. So I think that we have more than adequately satisfied the state's request. As to the DNA, I did speak with Mr. Gahn beforehand. Some of what he asked for in his October discovery demand, I didn't turn over because I thought it related only if Dr. Freeman had performed a separate independent test. I will take another look at that, and I think that we will work out whatever remains in that. I will turn over whatever protocol if he still wishes that, even though tests weren't done. But as to the others, I think we have more than satisfied the requirements. The court, Mr. Gahn. Attorney Gahn, Your Honor, even the Anderson case, when I read the Anderson case that Mr. Buting has provided under the Westlaw printout, this is a page 15 decision, or 15-page decision. And as far as the portion of the statutory section, 971.23, section 1, it's a mere one paragraph of, looks like 20 lines, and it's really is sort of an aside in the Anderson case. In fact, under State v. Anderson, the Supreme Court case at 291 Wisconsin 2D673, this Anderson case that the defense has cited was reversed by the Supreme Court. And they don't even mention this aspect. They don't even bring it up that I could find in the 40-page discussion. So the case being cited was reversed, and they didn't even address this very, very minor issue. What is said in the Anderson case is what their response to us has been. These experts may testify to something, they may not. They may agree, they may challenge. This is telling us absolutely nothing. This isn't the spirit of the statute or the spirit of the Schroeder case. If your expert is going to testify, tell us what their findings are and what their conclusions are, so that we can address that issue at trial. It is something that to state, as the defendant just said, that they gave a summary. I think he said, if I could just have one moment here while I get that it was, or the subject matter of his or her testimony. Well, to state something like that, they may testify to DNA frequencies. Well, that's such a broad, expansive topic, and that tells us nothing. What exactly is your findings on your conclusions as to the statistical analysis? That may or may not they may or may not testify as to the DNA protocols. Well, what the protocols are, 100 pages long, and they are all different types of, quality assurance, quality control. What exactly is the finding or conclusion of your expert that they have come up with? And they have not provided us with anything close to that. And I don't believe that that's in the spirit of Schroeder or in the spirit of the statute. we would ask that they make some more definitive and certain explanation to us of what their experts will testify to. Thank you, Judge. The court, all right, took the opportunity to review the legal authorities cited by the defense and also some of the other cases that interpreted in the statute in this case. I also read the defense disclosure of the potential expert witness that was offered. And the court concludes as to the follows. First, I think the defense adequately explained its use of the term may in the sense that it meant not that this may or may not be this expert's opinion, but rather that the state is not or the defense is not required to produce any expert testimony. And the defense used the term to indicate that it was not committing to calling these experts, only that it may call them. And I think that's perfectly appropriate. With respect to the meaning of the statute, the operative statutory language reads as follows. If an expert does not prepare a report or statement, a written summary of the expert's findings or the subject matter of his or her testimony are what must be provided. In the case law I examined, I found the most helpful explanation of that statutory language, which admittedly, when it uses the term subject matter, could be somewhat ambiguous. The most helpful explanation I found was in the case of State v. Revels, R-E-V-E-L-S, reported, and the court summarized its interpretation of the statutory language as follows. We agreed with the state that given the language of Section 971.23, Section 2M, and its obvious purpose, it must be construed to require disclosure of relevant substantive information that a defense expert is expected to present at trial, whether in the form of findings, test results, or a description of the expert's proposed testimony. The court also finds that it made that to be the most reasonable interpretation of the statutory language given the purpose for which the discovery is supposed to be provided. And as I take that standard and apply it against the disclosure that was prevented by the defense, I found that some cases that some of the information provided by the defense has met the standard. And in other situations, it falls short. For example, I'm not going to read it verbatim, but if counsel has the defense offer in front of it, the first full paragraph on page 3 describing what Dr. Fairgrave may testify about, I view as consistent with the type of information that's called for by the statute. If I look back at page 2 and read, for example, that Dr. Fairgrave may testify about the identification of human remains, including specific deficiencies in the recovery of the remains at issue in the case, the court finds that that type of information falls short of what the statute requires. The other side is entitled to know what are the specific deficiencies that are going to be testified about. Otherwise, the discovery doesn't serve its purpose. It doesn't allow the state to prepare for the type of evidence that's going to be admitted. And that's not to say that the defense is required to do the state's work for them. It's just to let the state know that it is going to have to perform on its own to answer the claims made by the defense experts. Another example, a little further on page 2, is the role of temperature and duration in the rendering of human body to remains. Well, what is that role? The state is entitled to know what the opinion or what the position of the defense expert is so that it can determine whether or not it agrees with that position or whether or not it tends to dispute the findings. Likewise, moving on to the statement of Dr. Freeman on page 5, it says he may be offered to testify about the reliability or lack thereof of the Wisconsin Crime Lab conclusions in the case. That's a conclusionary statement that doesn't really address the type of information the statute calls for. The defense is entitled to know what is it that the defense expert finds unreliable about the Wisconsin Crime Lab conclusions, again, so that the party can answer it. And although it's not the issue, I would hold the state to the same standard. standards in providing its expert information to the defense. So the court necessarily, in this case, cannot say with specificity exactly what the defense must do, but I do indicate that with the examples I have given, I found the defense disclosure of potential expert witnesses and summary of their expected testimony fall short of what the statute requires. And the court will grant the state's demand for compliance along the lines outlined by the court. The next item the court will address is the defendant's motion for disclosure of exculpatory information, which was filed on January 17th. Will that be Mr. Strain? Attorney Strain. Yes, that's I. Beauty gets the hard things, I get the easy ones. The case law on the state's due process obligation under the 14th Amendment to provide exculpatory information known to it is not entirely clear in the terms of what request or what specificity of the request the defendant must make to trigger fully the state's obligation of disclosure of exculpatory information. And I think it used to be clear that absent a defense request with some specifics about what it is that the defendant thought the state might have that is exculpatory, the state did not have a due process duty. Now, I think since Brady against Maryland, and assuming almost 44 years, the defendant's obligation to ask has somewhat eroded and has been replaced by an affirmative obligation of the state to tender. But this is the only way, I suppose, in which I'm conservative, but I'm conservative on this in the sense of I thought it better practice to ask with as much specificity as I could for what I think is the state may have, and in doing so invoke the state's due process duty to disclose to me. So this is a bit of a belt and suspenders approach. It was preceded by a narrow request in writing to Mr. Kratz that I didn't file with the court. But I thought, given the developments in the last couple of months, that it would be a good idea for me to make specific requests and thereby trigger the state's duty. There are ethical lawyers at the other table. I expect them to comply with the duty. And I don't know at this point the state or the court really needs to take any action other than requiring of the state. And I will say that I already know that some of the information within the scope of my request. So it's not that I'm completely in the dark necessarily on some of the information I seek. Rather, in a case this serious, I'm seeking to make sure that I've got it all. That if there's something that goes to the bias of the state's witness, or honestly, credibility of the state's witness, the state's witness motives to testify falsely, or to shady testimony, evidence that might support a defense or some mitigation of sentence, that I have asked for it and I have gotten everything, they may have that for stripe. So that's the reason for the motion. We don't have a specific dispute today, and as I say, other than inquiring probably of the state. I'm not sure that there's a ruling the court needs to make on the Brady motion today, but it was better practice to file it in my view. The court, all right, who will be addressing this matter for the state? Mr. Fallon? Attorney Fallon. Yes, thank you. I would frankly acknowledge that I would like a little bit of time to digest the request of the defense as it is framed within the context of an exculpatory evidence request. I did not receive the document until last evening, as I likewise was out of the office on Wednesday. The first thing I guess I would like to address is the responses to counsel's comments. Much of what he says I do not disagree with. This is, as he would say, a particularized or specific demand as opposed to the general demand that is in part and parcel of every criminal case. But I think, again, his argument and his request puts the cart before the horse, and to the extent that just because one says it is exculpatory or potentially exculpatory doesn't necessarily make it so. and I recognize that whether a bit of evidence or information is admissible is not the determinative standard as whether or not something is exculpatory or potentially exculpatory. So I acknowledge that, and I wanted to say that up front. But in having said that, in making a determination as to whether evidence is exculpatory or not, there is a materiality component here. And within the analysis of materiality, there is the overlapping of arguments as to whether such evidence would even be admissible. So I think we have to acknowledge that. And as I look at the information requested, that's what I'm struck by, and that is this information significantly material given all that I know now? And the court has had pretty extensive pleadings and briefs filed to evaluate the context in which this request is made. I have serious reservations as to whether it's truly material in the context of Brady, and I guess I would like to digest that and think about it further. Secondly, I'm not convinced that the information is solely or exclusively in the domain or the possession of the state per se. We have, as counsel readily acknowledges, 6 additional pages of discovery from their investigator regarding information that he has unearthed in his interview of members of the clerk staff, buildings and grounds, maintenance, and individuals and the like. Question is, they have subpoena capability as well as the state to get information. I can represent that in terms of the prosecution files, information that we have available. We don't have any of the information available to us. It's not in our possession. We will certainly look for that information, but I'm not conceding, for the sake of our argument here, that it's necessarily material, or that they are entitled to it, or it's solely in our possession, and we have an obligation to get it. We will look at the information, but again, much of the import of what's being asked here will be the subject of additional motion and argument at the end of the day to day, and that may or may not have an impact as to the materiality component. I wish I could say more, but only having it in an evening to digest this, that's about all I can say. We'll look at it. We'll make some inquiries because there are some interesting questions here. But we may by no means accept, for purposes of this, that it is an exculpatory information demand. We do not expect that it is necessarily material. I'm not saying it's not relevant. I will concede that. But then we have that whole materiality component. So that's our statement on this. We'll look into some of these matters, both as a courtesy and for our own information. We would certainly like to know some of this. I also believe that much of this has been complied with respect to some of our recent pleadings. And I would acknowledge, for instance, paragraph 2, our last pleading, I think we have answered that. Paragraph 5, I think recent discovery information, which should have been sent to the defense regarding the vial of blood, I think that has been complied with already. I would indicate with respect to item number 10, for instance, we are ourselves, correctly so, we're waiting for a report from the Mr. McCurdy at the FBI. We do not have that report. We have a request in. We're told it's coming, but we don't have it yet. So in terms of those specifics, those I think I can provide to you. With respect to the absence or presence of keys, I can tell you that after the recent discovery that we sent to the defense and discovery received from them, I'm not sure with respect to the keys and access issues that there is any more. We can certainly look. But I think Investigator Wiegert and Fassbender did a round of interviews regarding that point, and Defense Investigator Baez, I believe it is, likewise did some. I'm not sure that there's much more to be had there. Again, raising the question, I'm not convinced this is entirely in our bailiwick, but that's my comments at the moment. If I may confer with counsel for a second. The court, fine. Attorney Fallon, and again, as I said, I think further discussion, perhaps regarding the two motions at the end of the day, this can be discussed even more freely. So we'll pass on that. The court, Mr. String, Attorney String. There are three things I can add that will, I think, be helpful in reply. First, it's of course not at all uncommon that prosecutors dispute the materiality of information that may be exculpatory or dispute with the defense whether something is exculpatory. Common situation, advocates on both sides look at facts from their peculiar perspective and experience, of course. I request that in such situations, the state take the high road in the sense of erring on the side of disclosure, recognizing that as lawyers who defend people rather than prosecuting them, we may have a better sense of how to use something in an exculpatory fashion, or what an exculpatory admissible evidence, something inadmissible, may lead to. If the state is unwilling to do that in its announced pursuit of the truth, which would suggest erring on the side of disclosure, there is available the option of tendering something that's questionable from the state's advantage point to the court for an in-camera and neutral determination. I think for a lot of reasons that's less preferable than simply disclosing it and fighting it later about what it means, but it is an available option. And if nothing else, ought to be used here if the state has information about materiality might be in dispute. Second, and this is quite specific to the case, I recognize, and I want to make sure that the court and the counsel recognize here the contours as I see them of the application, particularly of a case like Kyles versus Whitley, the 1995 U.S. Supreme Court decision that discusses essentially what is a state or the prosecution mean. Does it mean only that lawyers who sit at the counsel table or who are employed by the district attorney's office? Does it include law enforcement officers? If so, how deep within the department, so to speak, or within the investigative agency? And this case, happily, is not typical in this sense. It's a Manitowoc County case as a matter of venue and as a matter of original statutory law enforcement obligation. We can fight about how completely or what this means, but on November 5, 2005, some steps were taken to turn over some level of investigative control to Calumet County Sheriff's Department. And there's no question that on or about November 5, I think it was November 5, but I could be off, a judge in this county entered an order appointing a special prosecutor from outside the county, hence Mr. Kratz's appearance. In my view, though, this lessens not only the obligations of the Manitowoc County Sheriff's Department to yield to prosecutors exculpatory information within its possession, at least if that's known by officers who took an active role in the investigation that led to the charges here. I further acknowledge that not only are there institutional problems in out-of-county people relating to in-county people and, maybe the informal working relationships that aren't what they would be within a county between a DA's office and the Sheriff's Department. But here, of course, the Manitowoc County Sheriff's Department conduct has been put at issue by the defense. And we have had the unusual situation of DCI investigators engaged in interviews, quasi-formal at least, law enforcement interviews of Manitowoc County Sheriff's Department or other Manitowoc County personnel. So there are practical problems, but it doesn't change, in my view, the due process obligation in the end route to pursuit and route to information that the Manitowoc County Sheriff's Department may have and to which the prosecution is entitled and to which it has a due process obligation to disclose to the defense. Third, the due process obligation, of course, is ongoing. So if compliance is complete today, it doesn't necessarily mean that it's complete for all time, obviously, as information is gleaned. And counsel acknowledges faithfully that the information covered by paragraph 10 should be disclosed to the defense, and says that can't and says that he can't disclose it yet because he doesn't have it. Well, if he doesn't have it, that's true. He can't. So he has an ongoing obligation. We were told by a Calumet County officer at last hearing in Chilton that this information had been received from the FBI, but that I told in fairness that the very same day the news was news to Mr. Kratz. And so I don't know. It doesn't matter. The point is that the obligation is ongoing, and I'm sure the state will comply with that. As to paragraph 5 in specific, the state has made reference to in recent filing to what it says is a phlebotomist says. But of all the interviews recently disclosed to us concerning the general topic of the blood vial, that's the interview that's missing. We don't have a report of any interview from the now retired phlebotomist, and I would expect to get that if in fact the state is representing what she says, and a pleading. I'm sure the state is doing that accurately, but I would expect to have the underlying witness statement, and I'm sure it will be disclosed by my friends at the next table. So this is an ongoing process, and I'll end where I started, which is to say the request has been made, the allegation triggered. And I don't know that the court can enter specific rulings today necessarily, but I wanted to make a record of it. And the nuances here, the relationship of some ranking members of the Manitowoc County Sheriff's Department with this particular prosecution team complicate, but don't alleviate the state's duty. The court, Mr. Fallon. Attorney Fallon. Yes, one final point, and I guess this dovetails back to recent discussion we just had regarding relief from the pretrial scheduling order, because this is a perfect example of what is rebuttal testimony. If the defense wants to put forth that defense that are suggesting and implying in their pleadings to date that they do so at their own peril. The state has indicated sought relief from that order on the specific vial and the other related matters. Well, here is a related matter. Now, admittedly, the whole concept of the rebuttal does not excuse one's obligation with respect to what's potentially exculpatory evidence. So I acknowledge that. But again, it is an example of the complexity of this case and the issues and the import. Again, the state doesn't have to show all of its cards with respect to how it will respond and refute certain defenses which are going to be proffered. We only have to show our hand or tip our hand if such information is going to be, quote, truly exculpatory in the meaning of that phrase. And again, as I said, I would like to review some of the law on that. I'm aware of the council's representations. In fact, I don't disagree with much of what he said at all in terms of what our obligations are. I'm quite aware of those obligations, and the fact that the prosecutor's obligation is to look in these areas immediately beyond their own office is pretty well settled in the law. So I don't take issue with that. But again, there is a relationship here between what is truly rebuttal and what is truly exculpatory. And if it is truly exculpatory, the council is absolutely correct. Anything short of that, then they go down the road at their peril, because we are entitled to respond as the law permits. And that's why the statute is written the way it is. And that's why the rebuttal is set up the way it is, such that the state has a fair and right to reply, since we have the burden of proof beyond a reasonable doubt. Thank you. The court. All right. First of all, I believe Mr. String is correct in the sense that I don't know that there's much that the court can decide about this motion today. I'm just going to make a couple of observations. To the extent, and I believe the parties will agree with this, to the extent that the state possesses information that may be exculpatory, the obligation to share that with the defense goes beyond the need for the defense to make a motion. Case law requires it. Section 973 or 971.23, Section 1H requires it by statute. And certainly the state is aware of a number of criminal cases where the convictions have been reversed because of the failure to provide exculpatory information. The motion for disclosure, to the extent it draws attention to any exculpatory information that the state may not have been aware of before, would assist the state, if you will, in determining the existence of the information and turning it over to the defense if both parties agree that it's exculpatory. The state, in any case, runs a risk if it doesn't turn over the evidence that is later determined to be exculpatory. If there's any evidence requested in the motion that doesn't fall under the hearing or heading of exculpatory evidence and has not been previously requested, the discovery deadline ended at December 15th, so it would not have been turned over. In addition, I will note that whether or not any evidence may be exculpatory and may be material to this case may depend on the outcome of the rulings of the motions on which the court has yet to rule. And as the defense counsel points out, the state's duty is ongoing. So there may be a duty to turn over evidence that hasn't been turned over yet, depending on the future court rulings. Having made those comments, which I think for the most part the parties reflect in their statements to the court today, I'm not going to issue any ruling on the motion at this time. If at some point in time the defense doesn't receive something it feels it is entitled to receive, that it is in existence, and wants to specifically renew the motion, I will take it up at that time. To be continued in part 2.